Good morning. The Senate Judiciary Committee will come to order, and committee and those in the committee meeting room and following along online want to welcome. We have a committee member today. I will call sort of a substitute or guest for today only. Senator Dietrich, if you want to introduce yourself for a moment and let us know what district, and that'd be great.
Thank you very much, Madam Chairman. Brenda Dietrich, I represent Senate District 20. I have to stop and think for a second. Senate District 20 here in Topeka, which is primarily Southwest Topeka. And I'm substituting today for Senator Thompson. Happy to be here. Thank you.
Thank you. Thank you for joining us today. So with that committee, then we will turn to our first order of business and open the hearing on Senate Bill 533, increasing the period of time that a person is disqualified from driving a commercial motor vehicle for certain violations and prohibiting prosecuting attorneys from concealing certain traffic violations from the CDLIS driver report for holders of commercial driver's licenses and commercial learner's permits. And with that, we will ask for a bill brief from the reviser, Mr. Thompson.
Thank you, Madam Chair. Good morning, committee. Jason Thompson, Office of Reviser of Statutes. You have the bill brief for SB 533. This comes to you from the Fed and State Affairs Committee. The two main things that this bill does are increase the period of time that a person disqualified from driving a commercial motor vehicle for certain violations has to serve, and second, prohibiting prosecuting attorneys from concealing certain traffic violations from a driver report that CDL holders are subject to. The first section is KSA 8-2, 142. That is the statute regarding disqualification from driving a commercial motor vehicle. You can see in the bill, the current law in subsection H provides that a person who's convicted of operating a commercial motor vehicle in violation of an out-of-service order shall be disqualified from driving a commercial motor vehicle for a period of not less than 90 days nor more than 1 year on their first violation, and then not less than 2 years, not less than 2 years nor more than 5 years on a second violation when a prior violation occurred within the previous immediately preceding 10 years. Those minimum periods are changed in the bill. So the maximum periods are not changed, but the minimum periods are changed from 90 days to 180 days on a first violation, and then from 1 year to 2 years on a second violation. You'll see those changes in subsection H, which is on page 2, down in lines 35 and 37. So those are the two changes there, 90 to 180 and 1 to 2 years. So a couple small changes, but of significance because it's the minimum period that those folks would be disqualified from driving a commercial motor vehicle. Section 2 then amends KSA 8-2, 150. That's the statute regarding restrictions on a driver or a holder of a commercial driver's license entering into a diversion agreement for certain violations of state or local traffic control laws. Those of you that have dealt with this topic before over the years know that the state law essentially prohibits diversion agreements in certain circumstances related to driving and commercial motor vehicle licenses. The bill adds this new subsection C, which begins on the bottom of page 4 and continues on to page 5, to provide that a prosecuting attorney shall not mask or defer imposition of judgment or allow an individual to enter into a diversion program that would prevent a commercial learner's permit or commercial driver's license holder's conviction from appearing on the CDLIS driver record of any violation of a state or local traffic control law that occurred in any type of motor vehicle. So again, it's not just a violation in a commercial vehicle, it's a violation in any type of motor vehicle that then cannot be diverted in a way that keeps it off of that driving record. The subsection does apply regardless of whether the driver was convicted for an offense committed in the state where the driver is licensed or any other state, so it's nationwide. And the subsection does have some exceptions. It does not apply to parking, vehicle weight, or vehicle defect violations. So those smaller violations are not prohibited from diversion, and they don't have to go on your record. But any bigger or sort of more major violations or violations that do not fall under those categories do have to be reported. The big example obviously being a DUI or a commercial DUI. Those are the biggest sort of violations that are after. With that, I'd be happy to answer any questions and also stand aside for the attorney from the department who really knows this area very well.
Thank you. Committee, any questions for the revisor? Seeing none, then we will invite the proponent conferee, Mr. Ted Smith, attorney, Kansas Department of Revenue, Division of Vehicles. Please introduce yourself and welcome to committee.
Good morning. Thank you, Chair Warren and members of the committee for hearing and considering Senate Bill 533. My name again is Ted Smith. I'm an attorney with the Department of Revenue. Been with the Revenue for about 20 years and have had the pleasure of dealing with commercial driver's license laws for most of that period. And looking at Senate Bill 533, it's important to understand at a very high level, when you deal with a regular driver's license, a non-commercial one, that's really a state-to-state issue. There's reciprocity between the states, but the states are left, they're really to their own devices about how they manage the regular driver's license. But when we enter into a commercial driver's license situation where it's interstate, the federal government has sort of stepped in and asked the states to basically participate in their system. Where information is better shared regarding conviction history or the safety or professional status of CDL drivers. That's why Senate Bill 533 is necessary, because although this prohibition on diversions has been on the books for almost 20 years, the state of Kansas still receives in the neighborhood of 40 to 100 a year. And we still work with a lot of small prosecutorial offices in rural communities trying to discourage the practice. And why it's so important is because while a diversion is understood and prepared for in the state of Kansas, a prosecutor, a criminal defense attorney, an insurance company understands what it is and what you can or cannot do with it. Every state has a different type of deferred prosecution or diversion program. In Kansas, ours is before the conviction. In states like Missouri, it's dismissed afterwards. Now, internally, in each one of those states, they understand, but that's a real database record-keeping challenge at a higher umbrella federal level to make sense from one state to another. And that's why they ask us to prohibit diversions and basically require CDL drivers caught in situations where they're driving a DUI or unsafely, that be convicted so that it's properly recorded so that other states will understand the good and the bad of a CDL driver's record. With regard to Section 1 regarding out-of-service issues, those are amendments we ask for to bring it consistent with current federal law. And with that, I'll stand for any questions.
Thank you. Before we entertain any questions from the committee, I will ask, are there any other proponent conferees in the committee meeting room or online? Not seeing any, then committee, any questions for our proponent conferee? Seeing none, then thank you for your testimony today and appreciate you bringing this to the attention of the legislature and for your appearance today. We will then ask, are there any neutral or opponent conferees in the committee meeting room or online? Seeing none, then we will close the hearing on Senate Bill 533. And committee, then we have next on the agenda, final action on House Bill 2377. 2377. That is correct. House Bill 2377 was a bill that we heard last session in committee and was passed favorably out of committee and was referred back to committee from the Senate General Orders because we needed an updated fiscal note regarding the amendments that committee here had made. So I did request that updated fiscal note. It should be in your committee folder. It is dated March 3rd, 2022. And we also have a letter from the U.S. Department of Transportation, Office of the Administrator, regarding the compliance that actually, I think it's Senate Bill 533 would bring, if it's codified, would bring Kansas into compliance with federal requirements that become effective in September of this year, which is why Senate Bill 533 would be necessary. And then that is what we have in our committee folder. But before we proceed, we'll ask for a brief bill brief from the reviser regarding the bill and some of the changes that we made in committee as a refresher as we work this today. So with that, the reviser, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson again. I'll come back up here because it's been a little while. You might have some questions about this one, so I'll stand up and not be at the table like normal. As you mentioned, Madam Chair, this committee passed out House Bill 2377 last session. So you do have an as amended by Senate committee version that is out there. It's been printed and it has your amendments on it. If you were to make further amendments or pass it back out, you would eventually adopt that committee report on the floor. So as of right now, it's not been adopted, but you have passed that out. It has been printed and we can refer to that and get those adopted later. And as you also mentioned, the amendments made by the Senate committee did two things. One, there were a couple policy changes that we'll talk about in just a minute. But two, you made a number of sentencing amendments that were consistent with the sentencing amendments already made in the bill, but we had kind of missed a couple. And unfortunately, the couple that were missed would have made a few repeat offenders not have the mandatory minimum terms of confinement that are necessary to receive certain federal funds. And that was the main thing the committee was hearing about, was that a couple more sentencing amendments were needed in order to bring our law in compliance with the federal requirements. And you did that with a couple of the sentencing amendments you made. And I think the updated memo from I'm trying to remember who this memo is from. Let's see. Oh, the updated memo from the Department of Transportation that you have that's dated March 3rd reflects that the state would be in compliance and we would not be jeopardizing federal funds with the bill as amended. And then it's also reflected in the fiscal note. That's March 7th that you also received in your packet that references not only would the state be in compliance with federal law, but another change in the bill may actually make the state eligible for up to $250,000 more from the federal government. And I'll try to explain that here in just a second as best I can. All right, so that's the real big picture, background, procedure sort of thing. Overall, the bill, just as a brief reminder, there's so many things in here, and I feel like I've spent my entire career here working on DUI issues, so we could talk about this for a long time and probably not even scratch the surface. There are four big pieces to the bill. One, it authorizes reinstatement of a driver's license for certain persons with an ignition interlock device restriction. And that's new section 1 that we'll talk about in just a second. 2, it requires persons with an ignition interlock device restriction to complete the program, the interlock device program, before their driving privileges are fully restored. So it's a completion-based, a compliance-based system that's not currently implemented in Kansas. The third change is that there are reduced ignition interlock device program costs and provided by the bill. And then the fourth main one I'd highlight is it modifies the criminal penalties for commercial DUI and also for regular DUI. And the biggest change in regard to the criminal sentencing is that we move from those felonies that are served in county jail to being on-grid felonies that are served in state prison. So that's the major sentencing change. And again, I'll circle back to that in a minute too. But those are kind of the four big things I highlight in the bill brief, and I'll highlight here for you in just a second. So turning then to new section 1, the request for reinstatement can be made if you've served your ignition interlock device restriction period and it's been extended for at least 5 years because you haven't proven compliance. Again, it's compliance-based, so you have to show you complied. You can apply and say, I've served my 5 years without violating I don't have any convictions or occurrences that are related to my driving record that would prohibit me from getting off of the interlock, and then the department would grant that request. As Senator Haley well knows, this is an ongoing issue that we've talked about for a number of years. What happens to those folks who are on interlock and keep getting extended because they don't prove they've had the device installed? The exit mechanism is provided in the bill, but you have to wait 5 years to get that mechanism to apply to you. So that's in the bill in new section 1, and I wanted to highlight that for you because that's a big policy change. The second thing I wanted to highlight was the sentencing issue. And that's in section 4, commercial DUI, KSA 8-2, 144, and also section 7, at least it was in the old bill, section 7, regular DUI, KSA 8-1567. And actually, I want to not highlight that one just yet. I'm sorry. I'll skip to that one at the end, the sentencing issue. So I'll highlight the second thing I want to highlight is the change to compliance-based removal. So as I mentioned, right now, you get an ignition interlock period, and when it expires, you're done. That's how the current law works. It's a year, 2 years, whatever. The bill would implement a compliance-based system. You would have to show compliance with all of the program requirements and then prove that to the Division of Vehicles before you would have the ignition interlock requirement removed. The bill as sent to you from the House said that you would be allowed off of the program once you served your required amount of time, and you had not more than 3 standard violations and no serious violation in the 90 consecutive days prior to your application for reinstatement. So that's what was sent to you. This committee amended that so that you would have to have no more than 1 standard violation and no serious violations in that 90-day period. So the House sent you 3, could have up to 3 violations and no serious, and the Senate committee said that's too many, and you reduced it to 1. So the bill as amended says 1, not 3. So that's the first major change that you made as a policy. And I'll highlight that change for you is on page 18 in lines, it's at the bottom of page 18, lines 42 and 43. So if you wanted to see that change, it's small, but it's obviously significant. Bottom of page 18. The other thing that the Senate committee changed is in regard to a person with an ignition interlock device that's installed requesting those reduced program costs. So right now there's a small fund that you can apply to and have your costs reimbursed to you or covered by the manufacturers. But this would implement a program run by the Division of Vehicles and in the Department of Revenue that a person who is required to have an ignition interlock device installed can request reduced program costs through the division. As sent to you, a person would be eligible if their annual household income was less than or equal to 300% of the federal poverty level, and this Senate committee reduced that to 150% of the federal poverty level. And that change is on page 22 in lines 8 and 9. So the House had 300% of the federal poverty level. This committee reduced that to 150% of the federal poverty level. Further, once you had that determination that you met that requirement, you were eligible for reduction of costs depending on what percentage you were at, from 90% of the program costs that you would pay all the way down to only paying 25% of the program costs. This committee decided to just make it a flat 50% of the program costs. And you'll see that change on page 22. It's in line 17, and then all the House language is kind of struck right below that. So as sent to you, you would qualify if you were 300% of federal poverty level, less than or equal to that, and you had a range of 90% payment to 25% payment. And the Senate committee decided to make it 150% of the federal poverty level, and then it's a flat 50% of the program costs. That's what you would pay if you met that threshold. Hopefully that clarifies those couple of policy differences on the program costs and the ignition interlock issues. Then the last thing I wanted to highlight was the sentencing issue that I mentioned earlier. And the biggest thing in commercial DUI and non-commercial DUI is that the penalty for those multiple offenders that's currently a non-grid felony, which means it's not served in prison, it's served in a county jail. Those are moved to severity level 6 person felonies, so they'd be on the grid and your time would be served in the federal prison. And that's part of where you get the fiscal note from, and you get the impact on prison beds, because these would be your repeat offenders. It's third, let's see, it's, I'm looking for my note on the commercial offenders, because that's the one I can't remember. Third or subsequent offenders on commercial DUI. Third or subsequent offenders for non-commercial DUI, but only if they have a prior conviction within the preceding 10 years. So it's not a complete look back. And also fourth and subsequent DUI offenders, right? So essentially third commercial and fourth DUI, and some third DUIs that have recent offenses. Those are the ones who could be going to prison under this new sentencing scheme. And with that, I would then just make the final note that you made a bunch of sentencing changes related to that, and you got a number of those in the bill as amended. Unfortunately, there are a couple more that we found in the interim, thanks to the eyes of many attorneys who practice in this area, and I greatly appreciate their help, and I appreciate the chairperson allowing me to continue working with those attorneys that worked for the Judicial Council group that brought you this bill, so we can essentially get it right. You've said this is the policy you want by sending this bill out last year, and so we have a little bit more cleanup to do on the sentencing, and at the appropriate time, I do have a balloon amendment that would do that. I also, in that balloon, have all the date updates that would be needed, because this is a carryover bill, and all the dates would need to be updated to 2021 or 2022 or 2023 appropriately. So at the appropriate time, I have that ready for you, and I guess I'll stop there and see if you have any questions.
Thank you, Mr. Thompson, for that very thorough bill brief. Appreciate that. Committee, questions for the reviser? Senator Haley.
Thank you, Madam Chair, and I'd like to echo gratitude for your going through that issue, Mr. Thompson. I'll be succinct. You did reference, and I think those who've been on this committee know that I've had an ongoing concern with how we implement ignition interlock especially for first-time DUI offenders. And just as an aside, Madam Chair and others, I served on Attorney General Carla Stovall's it was called FATAL, the acronym FATAL, but it was a task force for 2 years looking at DUI and evaluating the impact it has on our society. And I'm very sensitive in concert with not only the legislature, but entities like Mothers Against Drunk Driving, MAD as it's known, and others. So my heart is in the right place. But the policies that we've implemented regarding ignition interlock, I don't think, and have said for many years, don't line up with the legislative intent as to how we address this behavior. Succinctly now, in this measure, 2377, Mr. Thompson referenced that a concern I've had is that, again, the first-time offender would have to maintain having this device, this contraption that's fueled by this industry, the ignition interlock, have to show operation of the device prior to having a reinstatement of one's driving privileges. Mr. Thompson just said, and this is my question, that we have made or are making in this instant bill a quantum change, quantum leap, if I understand correctly, to not having to show operating a vehicle on a first-time offender for 5 years, the ignition interlock device, and then being eligible for the reinstatement of a driving privilege, even though they would not have to have been proven that they had the device installed. Is that correct, Mr. Thompson?
Go ahead, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson again. And Senator, I'll say generally, yes, I think you're on the right track. And I'll just clarify a couple things to make sure that I'm thinking it through properly as well. So the shift in the law is right now, if I'm a first-time offender, I have to either put interlock on my vehicle and show compliance for the period of time, or I say, for example, I don't have a vehicle. I can't put it on my car. And then my interlock period, as I understand, never ends. It just extends in perpetuity until I have a vehicle and I put interlock on it. And then I can have my interlock period start. And when I'm done with that period, I can take that device off and get full reinstatement to a license without an interlock restriction. So hopefully that makes sense. And I know, just to let everybody else in on the Senator Haley and I have had this conversation many, many times on a number of bills over the years because this issue keeps coming up. And the main concern that the senators express to me usually is it's folks without a vehicle. If you have a vehicle, you simply install the device, and once you've served your period, it's done, right? That's the current law. You don't have to show compliance necessarily. You just have to show installation and, you know, maintenance of the device, right? The shift in the bill is to compliance-based, right? So they're going to be looking at your record, and if you don't comply in that 90-day window right before you say, I'm done, I've served my period, and I'm going to ask for removal, there's a 90-day window they look back at, and they say, how many violations did you have? And under the Senate bill amendments, you would be allowed up to 1 standard violation, and you would be allowed no serious violations. So if any of those showed up, they would say, no, you're still on interlock. Apply again when you have a 90-day period that meets the requirements, right? So in theory, that could go on in perpetuity until the person complies. As a counterbalance to that, for the folks who never put interlock on their vehicle and never show compliance, Section 1 creates sort of a 5-year exit mechanism. If you show you didn't have any violations, you didn't even have a car, you've done nothing that would prohibit you from driving, and you apply to the division, you can say, I waited my 5 years, I never had a car, I never had interlock. They can let you off of that interlock requirement and reinstate your license. So I think that's part of what Section 1's aimed at, is the folks who just never get the device installed for one reason or another. And so you could essentially just opt out of installing the device and prove that you didn't have any violations and show that to the division and be allowed to get off of that requirement after 5 years. Or you install the device, you comply, and you get it taken off at the end of the period that's required by law. So there's a little bit of increased compliance requirements, but there's also that exit mechanism that's provided, maybe for the folks who can't comply. And I don't know that is going to satisfy Senator Haley's concerns with this overall, but the committee did attempt to address them and did hear testimony from Senator Haley in one form or another. And this was one way they thought they could address the issue.
Thank you. Yes, Senator Haley.
Madam Chair, this is really all the questions I have, but there will be some discussion of that I would like to rely, but in terms of the explanation of the bill, but there will be, I guess, some further discussion. I don't know when the appropriate time would be, but some of that may incorporate the insight that Mr. Thompson will be asked to illuminate. But in terms of understanding the mechanics of the bill, that's all. But I may want to visit briefly when the bill itself is being discussed. Thank you. Thank you, Mr. Thompson.
Sure. Thank you. Committee, other questions for the reviser? Seeing none, then, is there discussion on the bill? There are a couple of amendments that perhaps as we go through those and then can circle back to Senator Haley's questions on the bill as we work it. So with that, then, we have a balloon amendment that takes care of the date, because this is a carryover bill from last session, so we need to update the dates of the reference to current statutes that are being amended. And then we also did have, I think there was another amendment regarding the sentencing grid, I think. But in any event, we will ask the reviser, Mr. Thompson, for an explanation of the proposed amendment to the bill, that is technical updates.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office. And as you mentioned, nearly all of the amendments are dates, so I won't really highlight any of those. KSA 2020 SUP is updated to 2021. And in a couple places, there were rules and regs required by a date in 2022 that is about to pass. So those are moved to 2023. So that would be consistent with the policy of the bill. I would just highlight the sentencing updates. And as I mentioned, I'm calling these technical updates, even though most of the time I wouldn't use that term for a sentencing change that's substantive. But the policy in the bill is that you now have folks on the grid for these multiple offenses rather than the non-grid felonies that they were before. And when you do that, there are a few changes to the law that are needed because certain provisions just don't apply anymore or they're conflicting with grid statutes. So one of those is on page 12, and I'll just highlight that because it's a large strike. So this is in the commercial DUI section. We would strike that entire provision about supervision after an offender serves their sentence. The attorneys that I consulted with at the request of the, or by permission of the chair, pointed out that that's only in there because those are non-grid felonies. Once those are on the grid, that's covered by the sentencing grid statutes, and this would actually be a conflict. You want to remove that to do the policy here. So that's the one on page 12, that very large strike. And then there's some similar little changes to 8-1567. And unfortunately, this is such a long bill, I have to flip for a little bit to get to there. Those begin on pages like 24 is where I'm at. Yeah. So around pages 24 and 25 and 26 and 27. You'll see just little tiny changes throughout there just to kind of clean up the language and make it consistent throughout. Because we're talking about a number of days you have to serve and if you're in work release, etc. So there's not really any substance to that other than making it consistent with the policy you've already adopted. And then the last thing I'll point out is there's this huge strike in the bill of the current provisions, or not the current, of KSA 2020 SUP 21-6604. That begins on page 37, and it goes on for a number of pages. We have to remove that section from the bill because it's outdated. You amended it last year. And so we actually have to reinsert that section and in its current form because you have to amend the current law. And we just do the same changes to that section that your bill would have done. And I know that that's kind of an important one because it's one of the sentencing statutes that says that talks about what you can do in these felony cases that are not on the grid. So that's one of the small changes that is quite large, but it's really a small change sort of in context. And the new version of the statute is attached. It's following page 58. So the back of the bill has that statute in its current form with the amendments made again. Because you amended it last year, we have to do it that way. We have to strike it and put the new section back in. So make your balloon longer, and it'll make your bill longer because there'll be the whole section that's stricken, and then there'll be the same section put right back in after it. So, but that's what all that is.
Committee, questions for the revisor regarding the amendment? Seeing none, then I move we amend House Bill 2377 as amended with this amendment. Is there a second? Senator Wilborn, thank you for the second. Committee, any discussion on the motion? You have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. We are back on the bill. Are there other amendments? Senator Wilborn.
Thank you, Madam Chair. I do have an amendment. I think the revisor either has handed it out or it should be on your desk. It basically provides the Highway Patrol has oversight of state certification of ignition interlock manufacturers and their service providers. And would like Mr. Thompson to go into detail of all the changes in the amendment.
Thank you, and we will distribute that now and then have Mr. Thompson explain the proposed amendment. I was going to pass that down.
Thank you, Madam Chair. Jason Thompson again. Apologies. I'm also trying to email these to the committee secretary and everyone so they could be posted properly. All right. So as Senator Wilborn explained, this would add the contents of another bill to this bill. Senate Bill 146 is the number, and to refresh you, you can look in the title box there that I'd add on page 1. It's dealing with the Highway Patrol and oversight of state certification of ignition interlock manufacturers and their service providers. That's currently handled by the Division of Vehicles, the Department of Revenue, and that would be shifted to the Highway Patrol. And I say it's currently handled by Department of Revenue, but actually through a memorandum of understanding, is handled by the Highway Patrol, even though it doesn't say that in the statute. That's how it works in practice. This may look familiar to you. The Senate did pass Senate Bill 146 out earlier this year, 39-0. So it did pass the Senate, and I put it in here in essentially the same form as it left the Senate. There's two pieces to it. The two statutes that are added there on the first page are at issue. You'll see that they would just be inserted in the bill at the appropriate place, and that would make a change in KSA 8-241 just to change a reference from the division to the Highway Patrol, and from the Department of Revenue to the Highway Patrol. It's a small change. It's near the end of that section, and that's the only change to that section. And then in KSA 8-1014, there's a similar change from division to Highway Patrol. It's a small change in subsection B3, it looks like. You'd almost miss it if you're reading through it. It's the only change to that section. So the substance of it is really the amendments on the section that's already in this bill, which begin on page 18 and then continue on pages 20 and right. So on page 18, we have one of those division to Highway Patrol changes. Again, that's it. But then on page 20, we get into the real meat of the issue. So this is KSA 8-1016. And again, it's in the current bill because there are rules and regulations relating to interlock and the program costs and the level of the federal poverty level and all that. That's already in the bill. So what's changed here is to move the rules and regulations regarding the devices from the Secretary of Revenue to the Superintendent of the Highway Patrol. So they would be in charge of approving models and classes of devices, calibration and maintenance of devices and standards for that. And even these new requirements on page 21 about use and maintenance and reporting requirements. So the division, the Highway Patrol would get all of those responsibilities. They would not, however, get full rule and regulation authority. Some would need to stay with the division. So that's where I had to get a little bit creative and dealing with 146 being combined here. So at the bottom of page 21, all rules and regulations of the Secretary of Revenue adopted prior to these amendments that are described in subsection A are going to be moved to the Highway Patrol until they amend, revoke, or nullify those. So all those rules and regulations will carry over, and they become the Highway Patrol's rules and regulations until they're further amended or revoked, et cetera. And then down on the bottom of page 22, we have a provision that the Secretary of Revenue will adopt rules and regulations before March of 2023, establishing the requirements and guidelines for receiving reduced ignition interlock device program costs under just this subsection that's dealing with program costs and that level of poverty that you can meet and the percentage of the program costs you pay. So that piece would stay with the division and with Department of Revenue. All the other pieces about the devices would go to the Highway Patrol. So that's the merger of the two bills. Hopefully that explains it.
Thank you, Mr. Thompson. Committee questions for the reviser regarding the proposed amendment to add Senate Bill 146. Senator Haley.
As referenced, Madam Chair, we've contemplated this already. I guess my question is maybe not for Mr. Thompson, maybe for Senator Wilborn. Is this the fiscal note, I guess, the shift of implementing this would be we'll go from revenue to the highway. Is there a, for those who will be doing the review, I don't know if we know where that's going to be incurred. Are we shifting? Is there a fiscal note on this? I know it's internal, but are we just, or is it basically equal to that which the department incurs to implement the program as the patrol will incur?
Senator Wilborn?
Thank you, Madam Chair. It's my understanding both parties have agreed to this, as we stated before when we heard Senate Bill 146, and it was best that everyone agreed that it would be best under the supervision of the Kansas Highway Patrol, and if I recall correctly, that the impact was almost negligible.
Thank you. Senator Haley?
Sufficient. Thank you.
Thank you. Committee, other questions for the carrier of the amendment or the reviser? Seeing none, then, did you want to make a motion regarding your amendment, and we will seek a second?
Yes, Madam Chairman. I move this amendment that we amend into House Bill 2377 as amended.
Thank you. Committee, is there a second? Senator Bowers. Committee, you all have heard the motion. Those in favor signify by saying aye. Those opposed, no. The motion carries. We are back on the bill.
Madam Chair?
Committee, yes, Senator Haley.
Yes, Madam Chair, I have an amendment that I'd like to propose to 2377.
All right, thank you. I was going to propose an amendment, but we will we'll proceed. That's what I was talking to the reviser about. We'll go ahead and do this, and then yours will be next, and then we will ask for further amendments as well.
Thank you.
Thank you. The reviser is passing out the amendment that would add Senate Bill 533 that we just heard today. That would add that into House Bill 2377 as amended. And with that, we will ask for a short explanation of the amendment from the reviser.
Thank you, Madam Chair. Jason Thompson, Revisor's Office again. And I will do my best to keep this one shorter because you just heard the bill. So again, a merger of the two. One section not in the bill is that 8-2, 150, so I have to add it. The other section is in the bill.
Are you talking about when you say the bill, House Bill 2377 is amended, or 533? Yes. Thank you.
Sorry, Madam Chair, I apologize for the confusion there. Right, so one section from Senate Bill 533 that is not in House Bill 2377 is KSA 8-2, 150. So I would add that to House Bill 2377. You'll see that as an attachment. The other section from Senate Bill 533 is already in the bill. That's in House Bill 2377. That's KSA 8-2, 142. And you'll see on page 7, I've just made the same changes that were in Senate Bill 533, 180 days and 2 years, right? And then, as I mentioned, we would tack on 8-2, 150 as an attachment. It's on the final page of the bill, and it would read exactly the same as in Senate Bill 533. So that's the merger.
Thank you. Committee, questions for the reviser? Seeing none, then, I move that we amend House Bill 2377 as amended to add the contents as set forth in the proposed amendment to add the contents of Senate Bill 533. Is there a second for the motion? Yes, Senator Wilborn. Thank you. Committee, you have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. We are back on the bill. Senator Haley, did you have an amendment?
Yes, ma'am. If you would, please distribute it, Mr. Thompson, Ms. Sage. And I'll explain it while it's being distributed. We kind of alluded to it a moment ago, Madam Chair. This would basically make a first-time offender's suspension. It's probably no surprise to anyone who's been on the committee before. If you get your first DUI and you have no previous DUIs and your license is suspended for 1 year, then the question that comes forward then is the reinstatement after 1 year. The current law is, though this now underlying bill will change it to 5 years, but current law says that one must show that the device called ignition interlock has been installed for that 1 year suspension. The original legislative intent, Madam Chair and members, would be that ignition interlock would be an option to suspension, so that if someone were on a suspended license but wanted to drive after their first DUI, they could opt to get an ignition interlock and drive their car while they had a suspended license. The law has been, as I've alleged, perverted to show that one must have the ignition interlock on a car for 1 year in order to get reinstated. That was not the original intent. That is what it says today. This amendment would say that after 1 year suspension, as we're saying now under the underlying bill, after 5 years, if I understand correctly from what Mr. Thompson just outlined, instead of 5 years, it would be after 1 year of a suspended license, one may reinstate or apply to have reinstated one's driving privileges without necessarily showing that they had the contraption, the ignition interlock installed. One other just brief editorial. Mr. Thompson said that, it was people that didn't have a car who, were not able to show. That certainly is one. My larger concern is the family car, where there are multiple drivers of the family car, and everyone becomes then criminalized, I guess, or having to adopt to have to blow into this device. I mean, whether it's, the different spouses or whatever who are driving the same car, when in fact the one offender, the first time offender, has then made that family car subjected to having to have a device when the other person may not drive, the one who offended. We have people who can take public transportation, Uber, if you will, or take the bus. I've known people who have gone the year of their suspension, but don't have the additional fees or don't have a car and want to get reinstated, but are not able to do so. So that is essentially what the amendment would do. Would return it to what the law was supposed to originally did say, that it would be an option for that year if they chose to drive. But if not, that they could still be reinstated after 1 year. Finally, let me say, Madam Chair, I've had a lot of discussions with Mr. Smith, who's an authority on this, who's with us today, who spoke to 533 earlier. My understanding is it doesn't cost us, Kansas, any money at all. And I don't know if that's correct or not, but that if we don't have this initial 1 year suspension, it doesn't cost us any money to implement it as such. And I would be happy to stand for questions on that or to stand, for clarity or correction on it.
Committee, as a point of order, did you move the amendment? And if you did, then we'll need to get a second before further discussion. But
absolutely, Madam Chair.
And I don't mean close on the amendment, but just move, right?
I did that already.
Oh.
Okay. Thank you, Madam Chair. I'd like to move the amendment.
Do we have a second for the amendment? Senator Corson. And discussion, Senator Wilborn.
Thank you, Madam Chair. I do have a question, then an opinion. The question is, does this impact this $250,000 that would be coming down from federal funding by lightening the load? I don't know who to ask that of. Maybe the carrier of the amendment knows that.
Thank you. Senator Haley?
I don't. I've been told that we have in place significant penalties for those who are suspended, first-time suspensions already, and that we would not have a fiscal impact from federal funds. I don't know what that is, and I certainly would yield to Mr. Thompson, or if the chair would allow someone who I know is sitting in the courtroom, in the committee room that knows. But that would be the chair's discretion. I do want an accurate answer to the question as well.
Thank you. Senator Wilborn had his hand up with a possible reply.
Thank you, Madam Chair. I would ask your permission to redirect the question to the revisers.
Sure, Mr. Reviser.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. So I'll do my best to put together what I can read from the Department of Transportation in their memo to the Director of the Budget and from the fiscal note, and you have both those in your file. So essentially, Senator Haley is correct. The federal funding stream does not necessarily concern itself with first-time offenders, right? They're more concerned with repeat offenders, and that's the reason we have some of those sentencing provisions in the bill that I talked about, was to preserve federal funding. However, the department points out, or the Department of Transportation points out, by removing a motorized bicycle license, so motorized bicycle license, as you do in the bill, and requiring all offenders to have interlock, first time all the way through, you may make the state eligible for $250,000 or more in federal funding because of that requirement being fully implemented. So my understanding is the inverse of that would be if you allow first-time offenders to not have interlock required, you may not be able to access that extra money. So if that's the $250,000 that Senator Wilborn was referring to, I understand from the memo from the Department of Transportation, the state would be potentially eligible for that funding under the bill as amended by the Senate committee so far, but with this amendment would not be eligible for that extra $250,000. So we wouldn't lose anything, but we may not be able to access that additional funding that the senator was asking about.
Thank you. Senator Wilborn.
Thank you, Madam Chair. I would like to respond a little bit. I think it's clear that we run a risk again of federal funding. I too served on the failed task force under the Attorney General Stovall several years ago. And my recall wasn't exactly like my good friend and a man I respect a lot, Senator Haley. With what we have learned today, with the amendments we have made, we have what I consider to be a very solid bill, and the one that we need to move forward on to maintain the federal funding with confidence. So therefore, I oppose this amendment. Thank you.
Senator Haley.
Well, thank you, Madam Chair. Thank Mr. Thompson and Senator Wilborn for your insight. You know, there are very few people that are disaffected by this law, this misapplication of the original law. But I happen to know two of them who remain impoverished and without access to being able to drive after way serving past their suspension because they're not able to own a car or to implement the device on the car. If you look at surrounding states, which I've had an opportunity to study, ours is the higher standard, and Missouri certainly is one. I actually know one of the Kansans who went over and got a Missouri driver's license to be able to drive because they couldn't afford to own and operate the ignition interlock, and the other is still struggling to drive. That's my neighbor, actually, 3 doors down, and this is, again, a misapplication of the law. We need to make it right. I don't think we're going to lose any federal funds. We have skilled counsel at Department of Revenue, one sitting right here in the room today, who I think would not concur with Senator Wilborn's opinion, not to get into that, that we would be losing any money, period. We won't. What we will do is to return to common sense by what the word suspension means when a license is indeed suspended. You suspend somebody for a year, they can't do whatever it is they're licensed to do for a year, after which they should be able to if there's no subsequent problem, not if there's some other additional condition that was not incident to the original suspension. So I just, this is something that has been around for a decade. I think we've tried to address it. I remember Jeff King, Senator King, and I were trying to get this through that he left. But anyway, I would hope that we would put the common sense of what suspension means back in and would support this amendment, Madam Chair and members.
Thank you. Senator Wilborn.
Thank you, Madam Chair. I just got a note that the Kansas Department of Transportation said that this amendment would cause us not to qualify. The incentive says all offenders must have ID. So with that, I confirm my original statement. I oppose this amendment.
Committee, further discussion on the amendment? Seeing none, then, would you like to close, Senator Haley?
Let's put common sense back into our law. And I do support this amendment, and we will be happy to work out in conference if, in fact, there is some cost that I suggest would not be incurred.
Thank you. Thank you. Committee, you have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. It appears to the chair that the motion fails. We are back on the bill. And we have a request for division. So with that, committee, all those in favor of the amendment signify by raising your hand. Seeing two hands, all those opposed, please signify by raising your hand. Seeing four hands, the motion fails. Committee, we are back on the bill. Are there further amendments? Seeing none, then do we have a motion regarding the bill as amended? Senator Gossage.
Madam Chair, I move we pass House Bill number 2377 as amended, favorably for passage.
Committee, is there a second? Senator Haley. Committee, you have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Thank you, committee, for your diligent work on the bill, and want to also thank committee for their diligent work this session. We have heard everything from proposed constitutional amendments to judicial confirmation of Court of Appeals judges, to law and order bills, to civil procedure bills, to criminal procedure bills, and a myriad of other policy issues that are important to the state of Kansas. Want to thank committee members again for your diligent work. Want to thank our staff as well. The committee could not run like it does without you. You are the backbone of this committee, and you keep us running on time and efficiently, and you keep us informed. Want to thank you for that. Want to thank all the conferees who have appeared in person or on WebEx, and we understand it. To provide testimony to committee does take time out from your other commitments of the day and travel time sometimes as well. Thank you for that. We are honored to have you come speak to your legislature. It is your legislature, and we appreciate hearing from all those on the bills that we have discussed. We have had informational hearings as well. And you can, again, follow any of this in real time, and you can go back and look at it recorded as well. So with that, it has been an honor to again serve as your chair of this committee this year, and look forward to working with colleagues during the rest of this session, and we have a lot of work to continue to do. And Senator Haley is seeking recognition. Senator Haley.
Only to say, Madam Chair, that I've been, well, the longest serving member of this, have served as ranking Democrat for much of my 22 years in the Senate, and that during that time I've had 5 different chairs, and wanted to commend you in absentia for for the manner in which you have conducted the committee hearing and that these hearings have gone that you have held with aplomb. It should be noted here during the month of March, this is Women's History Month, and you made history being the chair of the Senate Judiciary, the first woman chair, and did so with aplomb and grace and a breadth of knowledge across the board in the issues, the various issues that were addressed. And it has been a pleasure to serve as your ranking on the committee with you. And should you not return in this capacity in the future, you have made a certain amount of history here. And I've enjoyed and appreciated the manner in which you've conducted the committee, and just wanted to add that expression as we conclude this particular session. Thank you, Madam Chair.
Well, thank you. And it has been an honor to serve with each and every one of the colleagues on this committee, including our substitute and guest members that we've had from time to time as well. And want to again thank our staff who has worked very, very hard. And just when you thought our work was concluded, it has come to my attention through our diligent staff who has worked on the committee that we might want to consider final action on the 2 bills that we heard yesterday. And so hang on for just a few more minutes, please. And we will first then look at possible final action on House Bill 2299, which relates to extending the time within which a search warrant may be executed. And with that, with a bill brief from the revisor.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. In the height of brevity, current law, 96 hours to execute a search warrant. The bill changes it to 240 hours to execute the warrant.
Committee questions for the revisor? Seeing none, then I do have one technical amendment to change the effective date from the publication in the statute book to the Kansas Register, and this would then get it to conference committee where we could work with our colleagues in the House on this particular bill. So with that, I move that we amend House Bill 2299 with the proposed amendment changing the effective date. Is there a second? Senator Gossage, thank you. Committee, you all have heard the motion. Those in favor signify by saying aye. Those opposed, no. The motion carries. Committee, is there a motion on the bill as amended? Senator Wilborn.
Madam Chair, I move that we move House Bill 2299 as amended out favorable for passage.
Committee, is there a second? Senator Gossage, thank you. Committee, you all have heard the motion. Those in favor signify by saying aye. Those opposed, no. The motion carries. And finally, I promise, the last bill that we will be working this session, at least before, actually the last bill we will be working this session. House Bill 2515, a bill that we heard yesterday. It relates to providing a mechanism to seek relief from registration requirements for drug offenders and expungement for such offenses. And 2515 that we heard yesterday. And I do have another technical amendment that would change the effective date of the bill from publication upon the statute book to in the Kansas Register. Again, this would get the bill to conference committee where we could work with our House colleagues on the bill. And with that, I move the amendment. Is there a second? Senator Gossage, thank you. Committee, any discussion on the amendment? Seeing none, then all those in favor signify by saying aye. Those opposed, no. The motion carries. We are back on the bill. I will move that we pass House Bill 2515 as amended favorably for passage. Is there a second? Senator Haley. Thank you. Committee, any discussion? Seeing none then, you all have heard the motion. Those in favor signify by saying aye. Those opposed, no. The motion carries. And just want to repeat everything we said before about the pleasure it's been to serve on the committee and with our colleagues. And we hear a repeat ditto from Senator Haley on his comments as well. And thank you again, committee, and our Kansans following along online and others who have been as well and who've been in the committee meeting room. And with that, committee, thank you again. We are adjourned.